So, starting in the United States, the Supreme Court rulings on President Donald Trump's financial records, which he has fought so hard to keep private. The judges have decided his tax returns can be made available to prosecutors in New York, but not yet to the US Congress. Just a bit of background for you. The Manhattan District Attorney wants the records as part of a criminal investigation into hush money payments made to women Trump allegedly had affairs with. The other ruling concerned two committees in the House of Representatives. They've been investigating potential foreign influence and Russian money laundering. The judges said that one needs to be decided by a lower court. And then we have had, well, there's been plenty of reaction from Donald Trump, but this was the first tweet. He talks about the Supreme Court sending it back to the lower court. He says it's all a political prosecution and goes on to say, I won the Mueller witch hunt, as he calls it. I have to keep fighting in a politically corrupt New York. It's not fair to this presidency or administration. OK, so here's our team covering events at the moment. Kimberly Halkett's at the White House. Kimberly, I'm going to come to you in a moment, a little more on Donald Trump's reaction and what it actually means for him going forward. But starting with Shihab Rattansi, who's at the Supreme Court. Take us through, and in the simplest terms possible, because I know it can get a bit complicated, but the ruling and also the way that the judges voted.
7-2 in both cases, including, so that means that Neil Gorsuch and Brett Kavanaugh, Donald Trump's appointees, were in the majority in both of these cases. The one that has gone against Donald Trump is that the New York case that you mentioned, the district attorney's grand jury investigation. They say they need financial records from Mazars, Trump's accounting firm, to look into allegations of financial impropriety and perhaps campaign finance violations and other things in relation to the payment of hush money to two women. This payment happened in the run-up to the election. These two women claimed that they had slept with Donald Trump. Donald Trump's lawyers had argued this is harassment, that this is a distraction from the presidential office. The president is immune from prosecution while he's in office anyway, but he should also be immune from having to hand over records and be involved in these sorts of proceedings, because it would be a distraction from his office and it's harassment. It would allow any district attorney in the country with a political axe to grind to start subpoenaing documents from the president just to bug him, basically, to prevent the president from doing his job. And the Supreme Court has rejected those arguments, both on Supreme Court precedent and for other reasons. We had Nixon handed over the Watergate tapes as a result of subpoena. Bill Clinton actually had a video deposition in the Paula Jones case for sexual harassment. So so they actually, they've handed over stuff. They've actually been deposed on video. So to say that a third party, your accounting firm, can't hand over some documents would be harassment, that's a bit much. And that will now go to the New York grand jury. But that doesn't mean we'll see it. The grand jury's deliberations are in private, and we will not see any of that information unless there is a leak. But then we have the second case, which had the potential for making Trump's closely guarded financial records public, which was the various congressional committees who've asked for information, both from Trump's accounting firm, but also from Deutsche Bank, the other bank, Capital One. And their reasons are, because we are concerned about Trump's, benefiting from the presidency, foreign interference, foreign leverage, campaign finance violations. I mean, it goes on and on and on. Michael Cohen, Donald Trump's lawyer, testified under oath in Congress that Donald Trump and his organization routinely fiddled the books to suggest yet less money to the Inland Revenue Service, the tax authorities, but more money to banks so he could get more favorable terms for loans. So the Congress said, look, we need to see all this stuff to make sure that our laws are working and whether they need to be changed. And so they were saying, look, we have a legislative reason for this. Trump's lawyer said, wait a second, there's no legislative reason. What legislative reason? Tell us what legislation this has to do with. This is a fishing expedition. You're just trying to find dirt on Donald Trump to use for politically motivated reasons, and that shouldn't be allowed. And that seems to be, and so the Supreme Court justices seem to have gone in the middle of that, saying, no, wait a second. If there is a specific legislative purpose, then Congress has every right to get those records. But if there isn't, then they shouldn't. They shouldn't be a law enforcement agency, as Trump lawyers kept saying. But the problem is, though, that when Congress, in making its arguments, didn't specify what laws any of this information would actually impinge upon. So they're saying, go back to the lower courts and make your case again and be more specific, and for the judges in the lower courts to be more careful as to whether the information that's being asked will really change legislation or whether it is actually just a politically motivated fishing expedition.
So can I return to the point you made earlier about the New York case where you said that we may not actually even see the taxes, because that I'm viewing everything in terms of an election campaign and how these things can influence things before November. Why would we possibly not see them?
Because the grand jury is an empaneled legislative function, one of the many that we have here. All their proceedings are in secret. But anyway, actually, it is precedent that a president will not be indicted anyway while in office. So even if the grand jury came to a conclusion that Donald Trump had done something wrong, he wouldn't be indicted anyway while he was in office. That's just the way that things have worked. There isn't necessarily a law in place like that, but that just is precedent. So there are two reasons. One, the grand jury's deliberations are in private. Two, President Trump isn't going to be indicted while in office. And that was another reason why Trump's lawyer said, well, why do you need all this information then? You can't even do anything with it.
Okay.
But the district attorney in New York said, no, we want the information while it's fresh and while it still exists, in case anything happens to it. But we want to get all this information while we can, while the information is actually there.
Gosh, it's complicated stuff, isn't it? But thank you for walking us through that. Shihab Rattansi, he's at the Supreme Court. As promised, Kimberly Halkett at the White House now. Kimberly, oh, there she is. Kimberly, I read one of Donald Trump's tweets out. He's kind of gone on a Category 5 tweet storm since then. What is his gripe, if I can put it that way at the moment? What is he claiming?
Yeah, I'll get to that in a second. I just want to put a fine point on your question to Shihab, because
Sure.
I have a bit of a passion for law. And so when it comes to a grand jury, they're very confusing. I didn't understand it until I moved to the United States myself. The sole job of a grand jury is to decide if charges should be laid. So the reason that we may not see this evidence that the grand jury can now see is because their only job is to decide, based on that evidence they review, if charges should be laid. Once charges are potentially laid against a president, then there would have to be a whole new trial, which the public potentially could see unless there were arguments to keep it in secret. And that is when some of that evidence may come up into the public domain. So I hope that clarifies a little bit about this timeline, because we know the wheels of justice move very slowly in the United States. Why potentially the president could allow this to be delayed beyond the timeline of November, which is the presidential election, which obviously he would want. Now, I should add, since we're talking about that, I have a statement from the Manhattan District Attorney, who is the one pushing for all of this to happen. And he says our investigation, delayed for a year, will resume, guided by the grand jury's
Kimberly,
obligation
I'm going to interrupt
follow
you.
the
I'm
facts
really sorry about
wherever
this,
they lead.
but we've got Nancy Pelosi, Speaker of the House, giving a statement at the moment. Let's have a listen.
The president is not above the law. And that was something that was proclaimed in the decision, including two of his recent appointments. A careful reading of the Supreme Court ruling related to the president's financial records is not good news for President Trump. The court has reaffirmed the Congress's authority to conduct oversight on behalf of the American people, as it asked for further information from Congress. Congress's constitutional responsibility to uncover the truth specifically related to the president's Russia connection that he is hiding. The Congress will continue to conduct oversight for the people, upholding the separation of powers that is the genius of our Constitution. We will continue to press our case in the lower courts. That's what happened this morning. Earlier this morning, for the 16th week in a row, over 1 million Americans applied for unemployment insurance. 16th week in a row. We have to open up our economy. We can only do so by killing off the virus. That's what's in the HEROES Act. Testing, tracing, treatment, separation, masking, wash your hands, Keep your distance, as I said. That is what is in the HEROES Act. There's the science, all of
So Nancy Pelosi moving on to some other issues now, but making the point that the Democrats would keep fighting this in the lower courts to try to get hold of Donald Trump's financial records so that Congress can see them, as opposed to just the DA in Manhattan. And that's what you, Kimberly, were telling us about when I had to interrupt you. Why don't you go back to that?
Yeah, well, I want to build on Nancy Pelosi's point because she makes a good one there. Again, for our viewers who are just joining us, we've had two rulings. One, that in the case of the Congress, that they wanted to see these financial records, and they're not getting them right now. In the case of the Manhattan District Attorney, they're going to have that evidence being put forward to a lower court is going to examine this case, but ultimately it's this grand jury that's going to likely get to see this information. But we heard there Nancy Pelosi talking about congressional authority. There is a constitutional mandate for the U.S. Congress to make sure that this executive branch behind me doesn't get too powerful, doesn't become an imperial presidency. That's these checks and balances that have been put into the U.S. Constitution in order to make sure that no president gets too big for his or her britches, if you will. So the Congress made this argument that they had a legitimate oversight responsibility to see this because they had questions about these tax returns. And the court said, well, you didn't make a strong enough argument. In fact, the argument that was made was very clear, is that Congress really needed to put forward a better argument in terms of their legislative duty, and they didn't do that. The argument comes down, indeed, the argument the House was unable to identify any type of information with some relation to potential legislation. So they kind of got their hands slapped. They're going to have to go back and do their homework, do a little bit more digging, have a better argument, and have it be based in some sort of evidence. And that's what Nancy Pelosi's just said. Yeah, we're going to do that. We have oversight responsibilities, so we're going to continue to do that. We're going to continue to make sure there's a separation of powers. Now, quickly, you wanted to talk about the president and what he's had to say. Category 5 tweet storm, absolutely. He's criticizing the previous administration. He's saying there's a double standard here, that they spied on the campaign, and that, in fact, he did nothing wrong. He points to the $45 million spent on whether or not there was Russian collusion in his 2016 presidential campaign. Ultimately, it says that there was none in that investigation. But the president says, you know, and despite all of this, these political motivated charges against me, he alleges that he says are really people that were not going to accept the results of a democratic election. He says, in spite of all that, I've done more, he claims, in 3.5 years than any other president. President often speaks in these sort of bellicose terms, very grand views of what he's done and has not done. The bottom line in all of this right now, I don't think it's moved the bar in terms of public opinion. Those that support the president probably still do. Those that don't are probably still not going to support him. And right now it's going to take some sort of big surprise, the October surprise we talk about, to really change the trajectory going up to the November election.
Great stuff from Kimberly Halkett, our White House correspondent. Thank you. And now some expert opinion from Claire Finkelstein, Professor of Law and Philosophy at the University of Pennsylvania, also Director of Faculty at its Center for Ethics and the Rule of Law. She's in Truro, Massachusetts. Hi, Claire. Do you know, just while we were talking to Kimberly, I thought of another question, and it's possibly my most simple question of the day, but I think it's worth going back to. Why are we even at this point? Don't presidents, or at least presidential candidates, usually release their tax and financial information?
Indeed, they do. But this president is taking the stance that he does not have to give the American people the transparency that former presidents and presidential candidates have always given. And so this has been a sore point, both for the American people, for Congress, and, of course, for the president on the other side, who keeps likely falsely claiming that he's under audit and therefore cannot release his tax returns. What's most important about today's decision is that the Supreme Court has reaffirmed, made very clear that the president is not above the law. He is subject to ordinary court procedures like Nixon and Clinton before him. He has to allow responses to subpoenas. In this case, it would have been quite shocking had it gone the other way, because the subpoena was issued not to the president directly, but to Mazars, his accountants. And they were willing to comply with the subpoena, but the president was trying to use his presidential privilege to block Mazars from complying. And here the Supreme Court has reaffirmed what it said in the case of Nixon and Clinton, namely the president does not have that scope of privilege. He is not able to say that he will block others from complying. He couldn't block it himself. And Mazars will have to turn over tax returns and financial records to the Manhattan District Attorney for
Claire,
use in a grand jury investigation.
Claire, the fact that the president's own men, if I can put it that way, that is the justices who he appointed, and he's very proud of appointing Republican judges all over the country, not just to the Supreme Court. The fact that they, at least in one of these cases, effectively voted against him, how much of a blow is that to the president?
This will be a huge blow to the president that Kavanaugh, of all people, the person that he fought so hard to get the nomination through when there were so many reasons for him not to be confirmed, has gone against him in this case. And I think that's a measure of just how clear the law is on this point, but also a measure of the fact that Justice Kavanaugh recognized for his own position that it would be extremely contradictory had he not supported this case, given that when he worked for Ken Starr in the Clinton investigation, he sided with the position that Clinton should have to answer questions about his relationship with Monica Lewinsky, indeed very detailed questions. So Kavanaugh would have had a very hard time saying that this subpoena should not be allowed to go through, though I'm sure that the president was counting on his support in this case.
Claire, I just want to read something to you and to our viewers. We've heard from the New York DA's office, the District Attorney's Office, a statement which says, in part, this is a tremendous victory for our nation's system of justice and its founding principle that no one, not even a president, is above the law. Our investigation, which was delayed for almost a year by this lawsuit, will resume, guided, as always, by the grand jury's solemn obligation to follow the law and the facts wherever they may lead. So, New York happy with that one, as they would be, Claire. But, as he talks about the process being ongoing, I mean, is it sort of one of those how long is a piece of string things? It could just carry on, remembering we've got an election in November?
That is the problematic side of this decision. What the court has done is to remand the case to the district court. And so Trump will try to make some additional arguments at that point that were not raised in the record above. I think he's going to have a very hard time with it, especially in the face of a 7-2 decision. That makes clear that this was not a close call. I am not at all clear what arguments he will try to raise, but it does mean that there'll be some additional court appearances, some additional arguments and briefs filed. I think that the district court is very likely to take its cue from the Supreme Court and to order that the financial records be released to Vance. Now, it's important to bear in mind, that doesn't mean that the American public and the world at large is going to be able to see those records. One of the points in favor of the Manhattan District Attorney is that grand jury proceedings are secret. And so the material that Mazars will have to produce now will very likely not see the light of day because it's very important to protect that grand jury secrecy. But what it does mean is that the president and the Trump organization can now be more thoroughly investigated by a Manhattan grand jury to see if any crimes were committed.
Right.
One of your speakers earlier said that it won't result in the president being indicted. I'm not so sure about that. If there is clear evidence of criminality in the president's behavior or the behavior of the Trump organization, especially in that case, there is actually no constitutional principle that says that a sitting president can't be indicted. He can certainly be investigated, and very possibly he could be indicted before he leaves office depending on what the grand jury finds.
Number one rule, expect the unexpected with this president, isn't it? Claire Finkelstein, always a pleasure talking to you. Thank you.
Thank you for having me.